Yes, ma, we can start.
Sure, sir. A very good evening to everyone who have joined us here today to be a part of this academic initiative. I am Sankirtana. I will be your moderator for today. I take immense pleasure in welcoming all the esteemed members of the KSBC Law Academy, distinguished advocates and lawyers, academic scholars, students, and everyone else who have joined us this evening to be a part of this imperative lecture series. Today is the third day of the week long lecture series. We request you to remain silent throughout the duration of the event, kindly requesting all of you to send across all your questions in the chat box. After the lecture is over, some of the selected questions will be posed to our esteemed speaker. Please utilize this opportunity. Now the forum is open to our esteemed speaker.
Hope I am audible.
Yes, sir.
Uh, Very good evening for this session. And yesterday and day before yesterday, we have had good session and good learning. How we have been speaking about the importance of evidence, law of evidence, and we have been speaking about the importance of Bharatiya Sakshya. As I have been repeatedly saying, that Bharatiya Sakshya Adhiniyam is largely nothing but the replica of the erstwhile Indian Evidence Act. There has been rearrangement of sections uh, that for the limited purpose of memorizing the rearrangement of sections, we may have to read it thoroughly. And of course, as I told in the very beginning itself, there has been a lot of developments. There has been a lot of uh, explanations that have been offered under the new law. Some illustrations under certain sections have changed in order to convey the illustrations, more effectively. Of course, there is some sections of the Indian Evidence Act have several sections. Few sections of the Indian Evidence Act have been mixed and kept under a single section under the Bharatiya Sakshya. But largely, as I said, the law remains the same. Yesterday, we stopped at section 19, and I told that section 19 we will have it tomorrow because of something which is very important. Yesterday, we were dealing with admissions. 19, section 19 of the Bharatiya Sakshya Adhiniyam falls under the category of admissions. Section 19 reads, proof of admissions against persons making them and by or on their behalf. Now, what is an admission? Admission is one is agreeing for something. See, generally, in a disputed situation, if there is always an agreement or disagreement. In the court, we hardly agree with the other side, and in the dispute resolution forum, we always don't agree with others. We always don't agree with the opposite party. We always tend to differ. We always have our own, explanation. We always feel that even if something which is a fact, which is put across by the opposite side, we feel that the context of that has to be presented in a manner which you want. Sometimes what happens, admissions though are one's own statement. Now, this particular section 19 deals with, should there be a proof of one's own admission. Now, instead of reading the section itself, the illustration which is provided under the section gives a clear picture as to what is this somebody trying to place a further proof of his own admission. Is it not sufficient to say that yes, I admit that? But the courts may not at times accept even when you are admitting certain things. We have heard so many instances, so many cases where some people volunteer to say, no, I only did it. So at least in criminal cases, many times we see this kind of a situation where the offender may be someone else and someone else would come and say that I only did this, I am surrendering, etc., etc. It is not that always the courts would readily believe an admission. And it is also not always the opposite party would accept an admission once just because it is made. Therefore, sometimes even if it is one's own admission, he may have to prove that yes, I have admitted it. Under what circumstances this comes in? So instead of reading the provision, I am just reading the illustration. Illustration A. I've been repeatedly saying the explanations under the provisions, the relevant sections, the illustrations provided under the relevant sections are very, very important. We as lawyers may have to read it because explanations and illustrations mostly forms the part of the very law, and without reading the explanation and without reading the illustrations, we may not be able to get the complete picture of what the provision of law exactly wants to say. Therefore, I am reading in the light of section 19, the first illustration. Illustration A. The question between A and B is whether a certain deed or is not forced. Please see the cryptic language that is used under the illustration. The illustration says there is some particular deed or a document or a testimony. The question is whether that particular deed is forced or is not forced. A affirms that it is genuine, B that it is forced. Once again, a conflicted situation. A says it is genuine, B says no, it's not genuine. A may prove a statement by B that the deed is genuine, and B may prove a statement by A that the deed is forced. At that time, what happens when some admission comes into a doubtful situation, a disputed situation, a litigated situation, that the admission itself can be proved by the one who is making it. See, not just here, I have said it in a previous judicial proceeding also, the same admission, and that has been accepted. This is what is a further proof of a particular admission. Similarly, the counterparty can also sometimes say, look, you have said in a previous proceeding that no, it is not genuine. Now you can't be admitting it as genuine. That is, you will have to have one single version. You cannot be switching over between different versions. So even if there is an admission which is made, and if it calls for further proof, the parties are entitled to give such a proof. Illustration B also gives a more, a larger insight. I am afraid if the same illustration was there in the Evidence Act 1872, but see how beautiful this illustration B is. A, the captain of a ship, is tried for casting her away. Now, don't imagine that because there is a feminine expression used, casting her away, that there is a lady. A ship is always considered a girl, and a feminine gender is used whenever you are referring to a ship, a vessel. So the illustration reads, A, the captain of a ship, is tried for casting her away. Casting her away means taking the ship away off its road, off its course. There is no road on the sea. It's called as course. Wherever the ship has to move, that's called as an en route. That's called as a course of its movement. So there is an allegation against one person that he took the ship away from its regular destination, destined course, destined movement of voyage, and he took it elsewhere. Now, evidence is given to show that the ship was taken out of her proper course. A produces a book kept by him in the ordinary course of his business, showing observations alleged to have been taken by him from day to day, and indicating that the ship was not taken out of her proper course. A may prove these statements because they would be admissible between the third parties if he were dead, under clause B of section 26. Even the illustration sometimes, even this kind of illustration sometimes does not convey immediately as we read. That means the law is not very easily understandable, is some fact which we have to accept at one particular point of one or the other particular point of time. Not every law is easily written, not every law is easily understandable. It is because a lawyer can have that art of understanding the law in its proper perspective, the lawyers are hired. Otherwise, there is no hard rule that a case has to be conducted before a judicial forum or a court only through a lawyer. If somebody doesn't want to engage a lawyer, if he thinks that he can do all by himself, they can always do it by themselves. Hiring of a lawyer is done just because lawyer knows better and lawyer can understand the law better. So we will have to do this complete justice when we are doing our job in the courts as lawyers and senior lawyers. And it will be certainly disastrous if we ourselves don't understand the law properly, the background of the law properly, and we go and try to advocate before the court for any of the clients holding a brief. Of course, it is not surprising that even lawyers can misunderstand law, because even the courts have many times misunderstood law. And unless and until the existence of appellate court system in our country itself, or in any country, in any judicial system for that matter itself, is a speaking proof that even the courts can do wrongs. The first court can do wrong, it can be corrected by a next court. The next court can do wrong, it can be corrected by an appellate court. If the appellate court also does wrong, it can be corrected by the Supreme Court. If one bench of the Supreme Court does wrong, it can be corrected again in a curative jurisdiction. We have seen so many cases where law was misunderstood many times and law was subsequently corrected. Why this is happening? It is because at the base level, if the correct understanding of the law happens, see, first, as the first duty of we lawyers is that we must first understand, and we must make our best efforts to make the honorable courts understand what exactly is the law is before we apply the particular portion of law or a particular law to a case in hand. Unless and until we are good in that, we can't blame the system. That if sometimes, many times, it's not that every judge has to know everything. It is, if your wrong understanding of the law, if you convey wrong understanding, the court believes it to be correct, then wrong judgments happen at the first instance, then it has to go to the second level, then it has to go to the third level. What if even at the third or fourth level, if the wrong is not understood, then we continue to follow a wrong judgment for a long time. This happened in a recent case when the Honorable Supreme Court was reconsidering the case of lawyers being brought under the purview of consumer law or not. One of the arguments was, no, in case of medical practitioners, this court has held that the medical practitioners have been brought under the jurisdiction of the consumer courts. Even the lawyers are doing the same kind of a service. Therefore, lawyers also should be brought under the purview of the Consumer Protection Act. The Honorable Supreme Court, after a detailed hearing, felt that no, lawyers cannot be brought under the brackets of a consumer court, and we also feel that the law which was earlier holding the field, where the Supreme Court, Honorable Supreme Court has said that the medical practitioners and doctors who have been brought under the brackets of the Consumer Protection Court needs reconsideration. So what does it mean? Even a wrong judgment would be followed for a long period. See what happens. I can cite you one more example. In respect of anticipatory bails, for a long time, Guru Baksha Singh Sibia was being followed as a best law. Thereafter, Salaluddin came and it did disturb the good judgment of Guru Baksha Singh Sibia for some time. But what happens by virtue of constitutional provisions 141 and 142, anything that is said by the Honorable Supreme Court becomes the law of the land. So all the inferior courts, maybe even the Honorable Supreme Court at times, has to follow once a law is declared. Now what happens? Guru Baksha Singh Sibia was disturbed by Salaluddin. Now, for a length of time, Salaluddin continued to hold. There was a deviation from Sibia till Sidram Satlingappa Maitre came. Sidram Satlingappa Maitre came and gave once again a new dimension, and in Sidram Satlingappa Maitre, the Honorable Supreme Court said the law which was declared in Guru Baksha Singh Sibia was a good law, and we should not have followed Salaluddin. But we had no choice as lawyers and as end clients. We can't say the Honorable Supreme Court has given a wrong judgment that I will not follow. So after Sidram Satlingappa Maitre, the anticipatory bail, the law was settled. We all thought the law was largely settled in anticipatory bail. But till Sushila Kumar Agarwal came, a new dimension was issued to anticipatory bail. In Sidram Satlingappa Maitre, it said, once bail is ever bail, there is no difference between an anticipatory bail and a regular bail. That's why once the bail is given, it is a bail forever. The length of the anticipatory bail or the term of the anticipatory bail cannot be curtailed, cannot be put under a time frame. It's once granted, it runs as a regular bail forever. But in Sushila Kumar Agarwal, the Honorable Supreme Court once again added a new dimension and said, no, no, even the anticipatory bail can be timely. If the court feels that it should be a time bound, it should be a term bound bail, it can say, and it can direct the parties to avail a regular bail later. See how the position of law keeps changing. Why does it happen? Did the law of evidence change? Did the law of criminal procedure change? Did the law of penalties, penal code change? No, laws never change. The laws remain the same. But the understanding of the law at different points of time in different perspectives change. Therefore, the best arrest for this kind, arrest means, how to avoid the situation. The best avoidance of these kind of conflicting judgments can be made if we, at the very level, very basic level, at the very base level, make a best attempt to convey to the court what exactly is the exact meaning and reading of law. Then remains a very less errors, furthering, very less errors in the next session. Therefore, I would request myself and all of us to understand the law, and when we are presenting a case before the first instance court, we tell to the honorable court, let us make all the efforts to tell to the honorable courts that what exactly is the exact meaning, intent, and exact delivery of law, intended meaning of law, so that sometimes whatever the lawyer says, the judges or the honorable courts may not agree, but you put it on record so that it remains. One fine day, certainly there will be a realization, yes, what was then argued, what was then found as incorrect is actually correct. Now, we see a lot of judgments in which there is a dissenting opinion by the honorable judges. What happens when there is a dissenting opinion? Even though there is a dissenting opinion, the dissenting opinion is subdued and the majority opinion will follow. Many times the Honorable Supreme Court and many times the Honorable High Courts have woken up to a situation that the dissenting opinion of a particular judge given on that day was actually the correct opinion, and therefore it should have been followed. A lot of entertaining, amusing stories about this, which we'll talk on a different day on a different occasion. Now, why I was telling all these things in the teeth of illustration B, please see how cryptic the illustration itself is. And the illustration itself is given to ease the provision of law, to ease the understanding of the main provision of law. But if the illustration is also not readily understandable, we have to make first, second, third, and fourth attempt, read the other illustrations accompanying that, then come back and read, and then we understand. Therefore, if one says, I'll read the law book once, and I'll read the provision of law once, and I'll go into the courts and I'll ram the courts, that is in fact a fallacy and it's a fiction. Every time you read law, you learn more. Every time you read the same sentence, you get to know more things. Now, once again, at the cost of repetitions, illustration B, under section 19, I am reading. A captain of a ship is tried for casting her away. Evidence is given to show that the ship was taken out of her proper course. A produces a book kept by him in the ordinary course of his business, showing the observations agreed to have been taken by him from day to day, and indicating that the ship was not taken out of her proper course. A may prove these statements because they would be admissible between the third parties. This last sentence is what that is little cryptic for us to understand. What is this? A may prove these statements because they would be admissible between the third parties if he were dead under clause B of section 26. What happens? A was tried for being rowing away the ship in a wrong direction, and he comes and shows, no, I did not change the course of the ship. I was in fact sailing the ship in the same direction. And he will show, look, I have kept all the logs in the book. Every time I have noted the longitude, every time I have noted the latitude, every time I have made these entries which I have to regularly make. Therefore, I have not been guilty. Don't try me. If this part, after he makes an entry, what if he is not there? He has made such entries. If he wants to use it in his favor, and if he is dead, once he is dead, any entries which is made during the normal course of a business becomes an evidence, an acceptable evidence, a relevant evidence if the person is dead or no more. The best example is dying declaration, which I will come a little later just after this. Therefore, section 19 deals with a situation where one has made an admission and there is a situation that the admission itself has to be proved, that I am agreeing something. I am agreeing something itself calls for a proof. Even that can be done, and that is relevant, is what section 19 says. Then section 20, when oral admissions as to the contents of documents are relevant. Of course, oral admissions as to the content of documents are relevant means, once again, it's a very brief section. Oral admissions as to the contents of a document are relevant unless and until the party proposing to prove them shows that he is entitled to give secondary evidence. Now, we'll come to primary evidence and secondary evidence a little later. So, to use the provision effectively and more fertilely under section 20, when oral admissions as to the contents of documents are relevant means when there has to be an entitlement for somebody to give secondary evidence. So when I am talking to you about the primary evidence, existence of when secondary evidence can be given, when it should not be given, when it is not allowed, when the case has to hinge or anchor upon the primary evidence only. If there is no primary evidence, there cannot be secondary evidence. All these things we'll talk later. Section 21, admissions in civil cases when relevant. This is a very, very important provision. Let me read it so you will understand the importance as I am reading. Many of us today, since in today's session, are also lawyers. As I read, you immediately understand. In civil cases, no admission is relevant. Please see, this is a negative provision. In civil cases, even if you come and make an admission, it is not relevant if it is made either upon an express condition that the evidence of it is not to be given, or under circumstances from which the court can infer that the parties agreed together that the evidence of it should not be given. If there is an agreement between the parties that something will not be used, if there is an agreement between the parties that this is an inter office document or a personal document between me and you, we will not use it, which should not be used, then there may be that non-disclosure, non-circumvent clauses which we see in several agreements. If there is agreement between the parties that something should not be used, even that particular document conveys an admission, then that cannot be given. In civil cases is the meaning. There is an explanation. Explanation is very, very important under this section because it does matter with we, the lawyers. I am reading the explanation. Nothing in this section shall be taken to exempt any advocate from giving evidence of any matter of which he may be compelled to give evidence under subsection 1 and 2 of section 132. This is something very interesting because under the Advocates Act, the lawyers are protected by something called as a privileged information. What is privileged information? The information which in the course of the interactions between a lawyer and his client, the information or whatever the divergences that would have been given by the client, his client, to a lawyer, it need not be divulged. We are all protected. Tomorrow if someone calls and please tell me what all your client said, we are not compelled. But there could be such a compulsion if the court compels the lawyer. Let us imagine a situation if there was, of course, the example which I am citing could be a little weird, but we keep seeing all strange cases, weird situations. That's the reason let us be as weird as possible. Now, if there is a situation where a client walks in to our office or any one of our office and says, "Sir, there is a complaint against me of me having forged signature or me having fabricated a document," and or else even if there is no complaint, he must as well come and confess with a lawyer, "Sir, there is something which I have done wrong. I am guilty of it. I am worried that I may be picked up tomorrow or picked on tomorrow by the law enforcement of whomsoever. I have forged a Mars card or I have forged some document. Would I have to take any measures, etc., etc.?" A client may walk into your office for consultation. Now, whatever he is telling to a lawyer, to you, to us as client, this is a privileged information. A lawyer knows that he has done something wrong. A lawyer knows that he is consulting He's being consulted by somebody who is guilty of having done something wrong. Now, this is a privileged information which I'll keep it with myself. I'll not divulge anywhere. Tomorrow, let us imagine a situation where he is caught in a different case. He is caught in a different case, and the investigation authorities or the court will find out that he had consulted such and such lawyer on a such and such occasion. He had shown all these documents and he had given all these documents in original at the lawyer's office, etc. If such a situation is there before the court, the honorable court can call upon. It appears that the same person who is now being charged or who is now being imputed for such and such offense had consulted you. What would you like to say? Produce all those documents which he had given you, or please tell to the court what did he say. Under such circumstances, even the lawyer cannot, we as advocates cannot refuse on the ground that it is a privileged information. The privileged information is privileged as long as it is a clean information. If it is an information of something against law, against the law of the land, if it is an information which itself has some other consequences under law, then we are not protecting a privileged information, but we are trying to hush up, or we are trying to go against the settled law of the country, settled law of the land. Therefore, Section 21 says admissions in civil cases when relevant, and explanation added to that clearly says, even as we lawyers, nothing in this section shall be taken to exempt any advocate from giving evidence of any matter of which he may be compelled to give evidence under sections 1 and 2 of section 132. 132 is little far. We will deal with a little later. Then section 22, confession caused by inducement, threat, coercion, or promise when irrelevant in criminal proceedings. This is what we see in many cases. This is a very, very important provision insofar as the lawyers practicing on the criminal side, criminal law side. I may say that the lawyers practicing on the criminal law side, they all may have to read this section 22 of Bharatiya Sakshya. This was there before, maybe under a different provision. It was there under section 24 and section 28. Now it is under section 22 of Bharatiya Sakshya Adhiniyam. I am reading once again the title: confession caused by inducement, threat, coercion, or promise when irrelevant in criminal proceedings. Now, I have to take you back to a little history when the laws were being debated, when the British wanted to make all those laws for us, and they were to be implemented, particularly section 161 and section 162 of the Criminal Procedure Code, which we used all along, which we are going to use even more, some more time till all the old cases get over. Now, under section 161, 162 of Criminal Procedure Code, the statements made to police are not to be signed, and it cannot be used for any other purpose except for recovery. I'm going to come to that a little later. Now, when the law was being made, it was being discussed those days. When you read the history of courts, history of law, then you will have a larger and a deeper insight into how these laws were made and what all the labor that went in before each and every provision of law were sculpted. Now, when section 161 and 162 was being placed, in Britain, in British atmosphere, even the statements made to the investigation officers can be signed and it can be used. A similar insistence was made here, but the lawmakers then, the commission, Macaulay, the commission, they said, no, we know the honesty levels of the investigation officers and the police machinery here. If such a provision is kept without metes and bounds, there will be a huge and a gross misuse of that. Every police officer will write something on his own, which does happen indeed on an everyday basis. It means, when you read a 161 statement, hardly a part of the statement might have been given by the person who is making it. It's all there when one writer who sits in the police station, he will write. Even if there is narration or no narration, then it will be presented before the court that this is the statement made by so and so, so and so. Therefore, the lawmakers are very conscious of the situation, the Indian conditions particularly, that if a provision is kept in such a manner, unbound manner, it was open for a gross misuse. Therefore, such a provision was kept under the procedure code and even under the Evidence Act. Confession caused by inducement, threat, coercion, or promise when irrelevant in criminal proceedings. To know this, we will have to understand what confession is. Confession is in Kannada tappopige, mean one is admitting his own guilt. Now, there could be a situation where in a criminal trial, an accused who is charged of a particular offense confesses to the court, and there could be conviction based upon confessions too. Now, what confession does? Confession, in fact, once if there is confession, there ends everything. One who admits by way of a confession, yes, I did this. I knew, I was aware that this was a crime, this was an offense, this was wrong, but still I did this. This is what is the confession. Now, how the confession has to be made? Confessions can be used against the person who has made it, but confessions made only under certain circumstances can be used. Confessions made anywhere and everywhere without following the process which is compelled under the law cannot be used. Now, in this background, let us read section 22. This is very important. I am getting a little deeper only into those sections which are very important, very relevant. Of course, it does not mean that other sections are not important. We hardly get to use those sections because those situations do not come frequently, and there could be rare situations where we may have to use rare provisions of the code, but I am going more on day-to-day situations, the situations which we often face. Therefore, those sections which are applicable to our everyday business and the business which we deal with quite frequently, those particular provisions I am reading with a little deeper, and at a little greater length. Now, section 22. A confession made by an accused person is irrelevant in a criminal proceeding if the making of the confession appears to the court to have been caused by inducement, threat, coercion, or promise having reference to the charge against the accused person, proceeding from a person in authority and sufficient, in the opinion of the court, to give the accused person grounds which would appear to him reasonable for supposing that making it he would gain any advantage or avoid any evil of a temporal nature in reference to the proceedings against him, provided that if the confession is made after impression caused by any such inducement, threat, coercion, or promise has in the opinion of the court been fully removed, it is relevant. Further provided that if such a confession is otherwise relevant, it does not become irrelevant merely because it was made under the promise of secrecy or in consequence of a deception practiced on the accused person for the purpose of obtaining it, or when he was drunk, or because it was made in answer to questions which he need not have answered, whatever may have been the form of those questions, or because he was not warned that he was not bound to make such confession and that evidence of it might be given against him. There are two things by reading this we understand. When was this law made? There was the same provision under the Evidence Act of 1872. You just imagine, we are talking about 1872. By 1872, each and every word, every punctuation that is employed under this section means a lot, conveys gigantic amount of information, gigantic amount of basis, knowledge, legal prescription. In 1872, the lawmakers could conceive such dense, intricate, and so intricately woven situations. You just imagine, the system in Britain was largely common law, and they had so many situations already that had come before the court which dealt with almost every area which is dealt under this provision, and therefore the lawmakers could comprehend, could in fact have a clear foresight what all could come in future. Therefore, let us make this provision of law so potent, rather omnipotent, that we fall behind, we'll fall shortage, we fall dearth of anything. Therefore, every word which is used is very, very important. The first part of it says confession which is caused by inducement, threat, coercion, promise, reward, etc. is immaterial. For example, somebody may be under a dire need of money to take care of his family, etc., etc. Now, what if somebody else has committed a crime and call this fellow, you go and confess, telling that as if you did it. I'll give you a lot of money. I'll give you a lot of reward for that. So, any confession which is caused by an inducement, by a promise of something, is not accepted. Secondly, if a confession is caused under threat or coercion, coercion means, you all know that coercion means trying to prevail upon somebody's mind by causing some kind of a fear, some kind of humiliation, or many things could be coercion. Therefore, any confession which is taken by the instrumentalities of these aspects, coercion, threat, inducement, promise, etc., are not accepted under the criminal jurisprudence. But the confession which is made after these factors are removed, threat, coercion, promise, etc., are removed, then that confession is acceptable. Now, how to remove this? A confession which is being made in a place where a person is not likely to be under such threat, such situation. What is the threat? Threat is threat tomorrow. If I make such a confession, what somebody may harm me. If I don't make such a confession, somebody may harm me. If I don't make such a confession, somebody may take away something from me. These are all the circumstances. To get a confession which is acceptable under law, these aspects should be removed. So, under what circumstances it is removed? Let us imagine a confession is being made by a person under the threat where the police will hit him, will subject him to torture, will subject him to that third degree treatment, what we call it as in general language. If a confession is given under such circumstances, the pain is the greatest promoting aspect. If person is put under extreme pain, he might as well make a confession which against his will. He might tell something which he doesn't want to say. Therefore, threat, coercion, torture, all these things are influencing factors. Suppose if a person who is making a confession is before a judge, is protected by a judicial atmosphere, by a judicial safety, then a person who is making confession under such circumstances, it is presumed that he was not under the threat of police. Then such confession can be accepted. But of course, a confession once made, it sometimes particular law, some of the judgments says a confession cannot be retracted, and some of the law says a confession can be retracted. We'll come to that a little later. The third part of this is when somebody is not in a situation of making a confession, just because he made that confession should we not accept it. Let us imagine the best example is what if someone is in an intoxicated state. ಎಲ್ಲರೂ ಹೇಳ್ತಾರೆ ಏನಂದ್ರೆ ಮನುಷ್ಯ ಕುಡಿದಿದ್ದಾಗ ಸತ್ಯ ಹೇಳ್ತಾನೆ ಅಂತ. ಯಾಕೆ ಅಂದ್ರೆ ಅವನ ಬ್ರೈನ್ ಅವನ ಹತೋಟಿನಲ್ಲಿ ಇರಲ್ಲ ಅಂತ. So a confession made will not itself become not acceptable just because he was in a drunken state, or just because he was deceived. ನೋಡಪ್ಪ ನೀನು ತಪ್ಪು ಮಾಡಿದ್ಯಾ, ನನಗೆ ಗೊತ್ತು, ನೀನು ತಪ್ಪು ಮಾಡಿದ್ಯಾ ಅನ್ನೋದು ನಿನಗೆ ಹೇಳ್ಬಿಟ್ರೆ ನಾನು ನಿನಗೆ ಏನಾದ್ರೂ ಮಾಡಿ ನಾಳೆ ರಕ್ಷಿಸ್ತೀನಿ. ದಟ್ ಮೀನ್ಸ್ he would say, I made this confession because I was given a promise of protection. Now, tomorrow if that promise of protection is not fulfilled, can somebody say, no, I made a confession under the promise of protection. Today they are not offering me that protection. They are not sponsoring my case. They are not putting lawyers for me. Therefore, that confession is not binding. The third part of the law says confession is also admissible in some circumstances, and it does not become inadmissible just because that it was made against a promise, just because it was made in a situation where I was not in a situation to understand that the confession made by me is likely to inculpate against me, or try is likely to incriminate against me, all these things. So therefore, my all friends who are more particularly practicing and who more particularly wants to practice on criminal law side, of course, a lawyer should not put meets and bounds to him saying that I am only a criminal law practitioner, I am only a civil law practitioner. One should be ready to practice every area of law. But what happens is, over a period of time, you go deep into a particular particular subject, particular area of law, area of legal practice, then you get a lot of expertise. It's humanly impossible for a single lawyer to be practicing in all the areas, because every law is a mammoth. So if you take, for example, tax law means that itself is a huge area of practice. So if you are practicing both on criminal side, tax side, civil side, etc., you may not be able to concentrate more on a particular subject. Therefore, we always choose areas of practice, and many of us may like to be on every area. But before getting into the court, advocating for a client, advocating for a litigant, we should be perfect. We have to make ourselves perfect, because a case or a client is not our learning material, is not a guinea pig on whose case we can dissect and we can make a surgery and try to learn out of it. Therefore, the third part is very, very important. Please read it carefully again and again. And what happens generally with all of us is one thing which is very, very strange, but it is an everyday's reality. We read law books when, as a matter of compulsion. We read it when we were answering those question papers, when we had to get graduated with a law degree. And after we get graduated, we always opened it only when we had the necessity of it, only when we had the need of it. So, unless and until you got a 138 case, a check bounce case in your office, you wouldn't see what Negotiable Instruments Act is. And therefore, this kind of an approach, I think we may have to cut down. Whenever we are free, let us try to read as much as possible, so that you go on excelling yourself. That when a client comes and sits in front of you, the client gets a first impression that this man is not reading from the books and trying to understand. He readily knows. That's what is expected out of a lawyer. Therefore, I would request all my friends to read again and again. Then we jump to section 23. Confession to police officer, quite important. Very particularly reads previous section. We read confession made under coercion, inducement, etc., etc. So there is more particularly a confession made to a police officer, when not to be used. This directly corresponds with the erstwhile section 161 and 162 of Criminal Procedure Code, with the changed provisions under the Suraksha Samhita. Now, section 23 reads, no confession made to a police officer shall be proved as against a person accused of any offense. 2 subsection 2, no confession made by any person while he is in the custody of police officer, unless it is made in the immediate presence of a magistrate, shall be proved against him, provided that when any fact is deposed to as discovered in consequence of information received from a person accused of any offense in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates to distinctly to the fact discovered, may be proved. Many of our law friends do not understand, especially my young lawyers may have to understand it very, very properly. First part says, no confession made to a police officer or no statement made to a police officer will be proved. You always see this something called as 161 statement, or Aropitana Svaicha Helike, is what which is read out in the court so many times. It is also produced along with the charge sheet. Final report contains this the voluntary statement of the accused, Aropitana Svaicha Helike. Now, can the court depend? Can the court use it? Is it relevant? It is not so what the law says. Whatever the statement which is made to a police officer, let it be called as a statement made to a police officer, as Aropitana Swaicha Alike, voluntary statement, and whatsoever the fashion. it cannot be used and it is irrelevant. But there is one exception to that. What is that exception? If something is discovered based on a statement made by a person who is making it. Let us imagine a situation where an accused was being interrogated, was being examined by the investigation officer. The investigation officer records whatever the accused is telling, his voluntary statement, etc., etc., etc. In his statement, first part will be ನಾವು ಹೆಂಗ್ ಮಾಡಿದ್ವಿ, ಹೆಂಗೆ ಎಲ್ಲೋದ್ವಿ, ಯಾವ ತರ ಯಾತಕ್ಕೋಸ್ಕರ ಕ್ರೈಮ್ ಮಾಡಿದ್ವಿ, what all we did, why we did this, why we hashed a conspiracy to kill somebody, why did we do it, what was our object, what was our intention, and how we did it, how all we prepared, who all did what, etc. All these things he will first say. Secondly, he will say, when we were committing this murder, I used a gun or a pistol and I shot at somebody and I killed him. And after this, we threw that particular pistol or a gun some particular place. And when we committed this murder, when we committed this crime, I was wearing some particular clothing which I later removed it and threw at a particular place. And after committing the murder, we took away a lot of valuables and belongings from the victim, and I have sold the valuables at such and such particular place, and I have used that particular money to buy such and such things from such and such place. So all these things may contain, all these things may come out in the statement of the accused or in the statement of confession which is being made by the person. Now, his statement in so far as where he is admitting something to the crime, that cannot be used. But based upon his statement, he would have said, I threw the gun at a particular place, and police would take him there and recover that particular weapon from a particular place. And he would say that I sold such and such valuables which were taken away by us from the victim in such and such place. Police would go to that place, recover those things which they have sold. And he would say, I bought such and such thing out of the crime proceeds. Police would go to the place and recover that. And he would have thrown his clothing which was there upon him when the crime was committed. The police would go and recover those clothing. So, in so far as the recoveries are concerned, whatever that is recovered based upon his statement, that particular part of his statement becomes relevant in criminal proceedings. This is what this particular section says, and we always have read this while referring to the old code. Section 160 of voluntary statement can be used only insofar as section 27 of the Evidence Act. So that's what is culled out and kept in a different provision here, but it remains the same. Therefore, keep it very, very carefully in your mind, and let's all bear it in our mind that when the police are using the voluntary statement, except for the recovery, the public prosecutor, when opts to argue after the trial is concluded based upon the voluntary statement, except for the recovery, you should straight away stand up and say, look, you are not supposed to argue this because this is irrelevant. You can only argue on the basis of that. We recovered this, the investigation officers recovered this, therefore only so much you can argue. That is also subject to contradictions and omissions, and it cannot be used for something else. This is what section 23 conveys us. Then section 24 says, consideration of proved confession affecting the person making and others jointly under trial for the same. This is quite important once again. Consideration of proved confession affecting the person making it and others jointly under trial for the same offense. Let us imagine in a case, there were 5 accused persons. One person makes a confession. Now, a confession made by one person, it can be used against him unless he was pardoned for being approver or whatsoever. That pardoning and all, it's what we see under the criminal code, criminal procedure code, and now the Suraksha Samhita. And let us imagine a situation apart from all that, if a confession is made by one of the accused, a statement made by the co-accused may not be relevant, but a confession made, we just above read, confession made under some circumstances can be used. If it was made subject to all those principles, if it was made in the presence of a magistrate, it was made to a judicially, if it was made in a judicially protected environment, etc., confessions become relevant. They're admissible in evidence. Now, what happens? Out of 5 accused persons, one person makes a confession. can it be used? This is what the law says. When more persons than one are being tried jointly for the same offense, and a confession made by one of such person affecting himself and some other of such person is proved, please underline this, is proved, the court may take into consideration such confession as against such other person as well as against the person who makes such confession. It's quite dangerous, because this straight away means to say that out of 5%, 1, 2, 3, 4, 5, person 1 makes, accused number 1 makes a confession, and the provision of law section 24 of Bharatiya Sakshya Adhiniyam says, and even the previous law said, it can be used against the other persons too, if subject to a condition. So what is the protection which is available? Subject to a condition, that if it is proved. So what comes into picture? That a confession which is made and the confession is being relied upon by the prosecution, and if that particular confession is proved, I am stressing here time and again proved, because we are going to a little later read and study what is proved, disproved, conclusive proof, etc., etc. At that time, I'll once again briefly reiterate this. But a confession of one accused persons made against the other co-accused persons can be used if it is proved. So proved means even a confession cannot be readily used unless it calls for a proof. So therefore, there is a wafer thin difference between a confession being used against a person who has made it and a confession being used against persons being used against others using a confession made by a particular person. So when it is being used against a person who has made it, unless he has retracted it, knowingly well that such a confession is there on the records of prosecution, it will be directly used, because it would fall under the bracket of certain kind of evidence which does not call for an additional corroboration or additional proof. But if it is being used against others, then it has to be proved. Now, who has the onus of proving or disproving? Let us imagine a little more advanced situation to this particular section. Let us imagine a situation. They have accused number 1, 2, 3, 4, 5. The accused number 1 would make a confession. Now he would stand quiet. His lawyer also would stand quiet. Now all the other accused persons who are also standing trial for the same offense, now they have to take a lot of care in attending to that confession. If they don't take a lot of care in attending to that confession, and if they don't try to rebut it, then it is going to be a big blow of axe and their necks too, because it straight away has a binding effect. Therefore, in a criminal trial, we have to be very careful. That's the reason we generally say having more lawyers. If there are more number of accused who have been accused of different roles in a particular crime, having separate lawyer is advisable, because one lawyer who is advocating for one person, if he says, if there is a single lawyer, if A1 has made a confusion, the same lawyer will be maybe in a very precarious situation to say that this confession cannot be used against A2, A3, A4, A5, who may be having some other defenses like a defense of alibi, defenses of non being present in the place, defense of being only being framed as a remote fact, etc., etc. Therefore, we have to be very careful, and the law is straight away fertile to that effect. When the law has a straight prescription, there is a great burden on the lawyer to overcome such a straight prescription. Then 25 deals with admissions not conclusive proof but may stop. 25 is a straight provision. Admissions are not conclusive proof of the matters admitted, but they may operate as estoppels under the provisions hereinafter contained. Estoppel is dealt under a different provision of the Bharatiya Sakshya. It was in fact dealt under a different provision of the earlier act. So the admissions not conclusive proof. That's the reason I said there are 3 or 4 different factors: proved, disproved, conclusive proof, etc., etc. Conclusive proofs means it is a proof in itself. It is a concluded proof. It does not require any further authentication, a further fortification. Therefore, whether the admission made by somebody, does it operate as a conclusive proof? No. The law says section 25 is very, very clear. It does not operate as a conclusive proof, but it will cause an estoppel. What is estoppel? In Kannada, I don't know how many of us may be able to understand. That's the reason, in fact, I was hesitant to deliver this lecture in Kannada, because if we start using the exact terminology in Kannada, we ourselves may not understand. Estoppel is called as Vagbandhana Siddhanta in Kannada. How many of us are able to understand what is Vagbandhana? Therefore, it is better to understand in a language which we have been using on an everyday basis. Estoppel means once you say something, you're bound by your tongue. You can't be changing your version, because you're saying something today. You have to, it stops you from changing the versions. So the doctrine of estoppel, which we will learn a little later, binds somebody. Once I have said something, I'm stopped from changing something else. Once I say something belongs to me, it stops me from differing tomorrow. It does not belong to me. Let us imagine a strange situation. If there is a bag which is kept in front of your house or in front of your door, somebody will come and ask, once you open the door, does it belong to you? And you think that there is a bag and the bag may be containing valuables, etc., etc., etc. You will come under the lure of all that, thinking that the bag has something very enriching. You will say, yes, it does belong to me. This is my bag. We bought it from such and such place, etc., etc. You will add a little more, spicy story to that, and you will say, no, it does belong to me. No, we bought it from such and such place, and we have kept it just because we are just going out, etc., etc. You will try to defend yourself, saying that it belongs to you. After some time, there will be a police siren in the same road, and this fellow will ask, somebody will come and ask, see, the police siren is coming. Why the police siren is coming? It appears that someone has robbed somebody's money, and someone has cut somebody's hand, put it in a particular bag which looks like this, and they have kept it, they have thrown it somewhere. Maybe this is that bag. The moment you come to know the bag has somebody's severed hand, the bag has somebody's robbed jewels, and the police are going to come at your door, you'll suddenly start saying, no, I don't know who this bag is. A simplest example, estoppel. Once earlier you said it belongs to you. Today, just because you come to know, it is likely to affect you. There may be even such intricate situations. Once you say, admitted something as something because it was favorable to you, and the moment you come to know the situation is not favorable to you, if you hang by the same admission, then you will say, no, it does not belong to me. Therefore, the doctrine of estoppel binds somebody from changing versions. This is what is called Vagbandhana Siddhanta. In Kannada, it is even more beautiful. Vak means say, word uttered. Vak means Vak Swatantra. We say the voice, the right to speak. Vagbandhana means once you say something, you are bandhana. You are, in fact, it binds you. Bandhana means it binds you. It cannot allow you to change. Therefore, the admissions do not accept it as conclusive proofs. They do act as estoppel, and estoppel can step in. You may not be able to change the version later. 26 says, cases in which the statement of relevant fact by a person who is dead or cannot be found. This is something called as dying. Of course, dying declaration falls under this. Why a statement made by somebody who is dead and no more, who cannot be found, is relevant, is a person who has made a statement at the time of making may not know that he is making it for a particular purpose. Try to understand this. A person in a general course, when he is not under the influence of any situation, any pressurizing factors, makes a general statement. makes a general statement. Let us suppose I am standing in front of court hall number 10 of the Honorable High Court. I would simply make a statement. Today, ನಾನು ಇವತ್ತು ಅಲ್ಲಿದ್ದೆ ರೀ, ಕೋರ್ಟ್ ಹಾಲ್ ನಂಬರ್ 10 ಮುಂದೆ ಇದ್ದಾಗ ನನಗೆ ಇಂಥವ್ರು ಸಿಕ್ಕಿದ್ರು. So I have made a statement in a general situation that I was standing in front of court hall number 10. Court hall number 10, because this is a general statement. Now, tomorrow, if I am not found, tomorrow, if I am no more existing, I am unable to be found, my statement that to the effect that I was standing in front of court hall number 10 on a particular day, which is made on a particular day, becomes relevant when I am not there, because it cannot be disputed, because I have made that statement on a particular day without any purpose, without any inducement, without any underlying objective. Therefore, if I am not there tomorrow, if I cannot be found, if I cannot be secured, a general statement made, if there is a recording to the effect that I stood in front of court hall number 10 and made such a statement, that is relevant without any particular proof, because whatever that is said in a general course of life by a person who is dead or no more, who cannot be found, who cannot be secured, becomes relevant because they cannot be disputed, because the person himself is not existing to dispute that particular fact. Then there are a lot of illustrations under section 26. Every illustration is a masterpiece of an example. Please read it with the paucity of time. I may not be able to read all the illustrations. There are illustrations A to N, so many, because the lawmakers could conceive so many different situations. Illustration is not just because going on giving one or the other example. Every illustration under the law means every illustration poses a different situation. It's not that I'm giving example A, example B, example C. Illustration is unlike an example. An example could be the same kind of an event, but an illustration is different kind of situation that can be reckoned to a particular aspect. To a particular law, when we are reading a particular provision of law, there are several illustrations, means every illustration deals with a different style and different kind of situation to which this particular provision of law might get applied. Therefore, giving many illustrations means the makers of law had a situation, had a thought process running in their mind that this law could be interpreted in different ways, in different situations. Therefore, let us give as many as illustrations possible. Of course, the illustrations are not exhaustive. There could be more kind of situations which are even alien to these illustrations that are piled up and kept under the very provision of law. So the lawmakers were careful to even conceive and perceive so many such situations of a different kind. Therefore, many illustrations are there. I would request all of you to read such situations. 27 reads, relevancy of certain evidence of proving in subsequent proceedings truth of facts therein stated. Please read it. It directly conveys the meaning. 28 reads, entries in books of account when relevant, when they are made in a regular course. Let us suppose in a merchant shop, every sale is made. He is made an entry by demand of law, by prescription of law. Now GST says every sale made has to be entered into a GST register. So every entry made in a books of account in a regular course which is maintained, that becomes relevant when you have to prove something. Suppose if you are saying, if you are suing somebody for compensation, for having given you a substandard item, for a substandard goods, tomorrow you can call for such record and use it in the court that ನೋಡಿ ನೀವು ನನಗೆ ಕರೆಕ್ಟ್ ಆಗಿ ಕ್ವಾಲಿಟಿ ಇರೋ ಐಟಮ್ ಮಾರಿದ್ರೆ GST ಯಾವುದಕ್ಕೆ ಅಪ್ಲೈ ಆಗೋದು? GST is applicable to the genuine goods because it would have been procured from a genuine source. So can you please show me, have you made an entry in the GST register about the goods which you have sold? If he is unable to show you, that means he has not sold you a standard genuine item, because if a genuine item was sold, it must find an entry in the GST register because he has to take the input credit for the GST. Therefore, all these entries which are regularly made in regular course of business in the books of accounts bank registers, every withdrawal, every deposit is an entry, there is an entry. These things are called general business books or general business records. They all are relevant when an issue, a fact in issue pertains to these things. 29 reads relevancy of entry in public record or an electronic record made in performance of a duty. You know, RTCs, PANIs and all these things, they are all entries in the public record. They are relevant. They can't be generally, denied. Of course, there are certain things which have the quality of a proof in itself, which part we will read it a little later. When we are reading proof, there are certain things which we are presumed to be correct unless disproved. Suppose if there is an RTC which is found on the revenue office record, the RTC is readily an acceptable proof by itself. So if you want to rebut that, you will have to show that RTC entry itself is wrongly made. So unless a rebuttal is done, there are certain entries that are made in the regular course of government records and the record made in performance of a duty. Let us suppose the police, every day they'll have to maintain a station house diary, beat book, etc. They are made in the regular course of duty. They are acceptable straight away and they are relevant. Section 30 reads relevancy of statements in maps, charts and plans. They are also like, nobody can deny this is not the map of India. So therefore, these are the things that whatever that is straightly understandable, I am skipping that. 31 reads relevancy of statements of the fact in public nature contained in certain acts and notifications. They are all gazettes and all that. They are all how much they are relevant. Now, 32 relevancy of statements to any law contained in any law books, including electronic or digital form. No need of much explanation. There are something. A law book has something printed in it in a particular form. It's expected that it is printed as it is. Of course, there are certain exceptional situations. There are so many law publishers. Sometimes we come across some wrong printing, wrong, spelling errors. Accepting those situations, when a court has to form an opinion as to law of any country, any statement or such law contained in a book purporting to be printed or published, including in electronic or digital form under the authority of the government of such country, or to contain any such law and any report of ruling of the court of such country contained in a book, including in electronic or digital form purporting to be a report of such rulings, is relevant. Means if the court is posed with a situation, ನೋಡಿ ಇಂಗ್ಲೆಂಡ್ ನಲ್ಲಿ ಈ ತರ ಕಾನೂನು ಇದೆ. ನಾವು ಈ ಡೈವೋರ್ಸ್ ಕೇಸ್ಗಳಲ್ಲಿ ಬಹಳ ನೋಡ್ತೀವಿ ಇದನ್ನ. ಏನಪ್ಪಾ ಅಂದ್ರೆ there are so many divorces that happen in a foreign country. Especially we have been seeing a lot of this employees who are on the software side and who are on this engineering side. They're in fact stationed abroad. They must have undergone a procedure for dissolution of marriage. Now the extended version of the particular dispute, same dispute may come into Indian courts. Then they will produce some law which is applied in American court, some judgments or some paper which is used in American court. As per that particular law, there is such and such order. Then the court will ask, produce that paper, produce that law book, produce that portion of law. And when the court is posed with a situation of dealing with such situations, that particular portion of law which is practiced in that country, that particular portion of a law book which is used in that particular court, all those becomes relevant is what it says. 33, what evidence to be given when statement forms a part of conversation, document, electronic record, book or series of letters, papers. Section 33 is on a different platform than the relevancy, because it says what evidence to be given when a statement forms a part of conversation, document, electronic record, book, series, etc. Please read it. What has to be given to prove something which is in the form of a conversation, document, electronic record, book or series or letters or papers. We generally counter this situation. Conversation record ಮಾಡಿದಾರೆ ಸರ್ ಅವರು, ಯಾವುದೋ ಒಂದು ರೆಕಾರ್ಡ್ ಇಟ್ಕೊಂಡ್ ಬಂದಿದ್ರು, ಮೈಕ್ ಇಟ್ಕೊಂಡಿದ್ರು, phone ನಲ್ಲಿ mobile phone, using a mobile phone, a particular conversation is recorded. This we see in this PC Act cases, Prevention of Corruption Act cases. Now, when someone has to place a record of such conversation, what is the evidence that has to be given? Now, we all know that earlier, now under the new law also such a certificate is there. Under the Evidence Act, section 65B provides that an electronic record has to be certified. There is a very beautiful judgment of our Honorable High Court when His Lordship Justice Anil Serene was sitting in division bench, where some CCTV recordings of a particular crime was produced. The CCTV recordings perhaps showed a very glaring incident of assault, etc. The Honorable High Court said, no, we are not going to accept this, though we see it is a recording, it is something visible that somebody is committing a crime, though it is recorded, because it is not produced in a manner known to law with a necessary certificate, we are not going to look into that. So therefore, we may fall into such situation. Somebody may produce an email. So what evidence has to be given when a conversation is produced, when an email is produced, when an electronic record is produced? What is the evidence that has to be given before the court to substantiate that particular material, which itself is an evidence in it? Therefore, to substantiate, to corroborate a particular evidence which is in the form of a conversation, which is in the form of an electronic record, which is in the form of a book, to corroborate that, what is the evidence that has to be given is what section 33 deals. I think I should stop here because section 34 reads with previous judgments relevant to bar a second suit or trial. Of course, I am not going to emphasize much on this. This is more that matters on res judicata, where there was a previous case, etc. Then section 35, relevancy of certain judgments in probate, etc. The previous judgment, what all is relevant, because when you are criming a probate, I think all of us must know what is a probate. Probate is an authentication of a will. So when you are proving a particular probate, what is the relevancy of other documents, previous judgments, etc. 36 reads relevancy and effect of judgments, orders or decrees other than those mentioned in 35. 35 expressed with relevancy of probate judgments with relevancy with respect to probate. Then section 36 reads in a different gamut, relevancy of effect of judgments, orders and decrees other than those mentioned in 35, straight away understandable as you read the provision. Then 37, judgments, etc., other than those mentioned in 34, 35, 36, once again, straight away understandable, no need of any further requirement of explanation. 38, fraud or collusion in obtaining judgment or incompetency of court may be proved. Now, we many times come and say, with this I will stop for the day. I think I have exceeded my time today. With this I will stop at 38. Sometimes, many times we come to court and say this judgment is obtained out of fraud. Swami, ಯಾವ್ಯಾವುದೋ ಡಾಕ್ಯುಮೆಂಟ್ಸು ಫೋರ್ಜ್ಡ್ ಸರ್ಟಿಫಿಕೇಟ್ ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬಿಟ್ಟು ಜಡ್ಜ್ಮೆಂಟ್ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಎಕ್ಸ್ಪಾರ್ಟೆ ಆರ್ಡರ್ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ ಬಹಳಷ್ಟು ಸಲ ನಾವು ಕೋರ್ಟ್ಗಳ ಮುಂದೆ ಬಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀವಿ. ಅಥವಾ ಅವರಿಬ್ರು ಕೊಲ್ಯೂಷನ್ ಫ್ರಾಡ್ ಮಾಡ್ಬಿಟ್ಟು ಜಡ್ಜ್ಮೆಂಟ್ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ, ನಂದು ಪ್ರಾಪರ್ಟಿ, ಅವರು ಒಬ್ಬ ನಂದು ಅಂತ ಅವ್ರ ಮೇಲೆ ಅವರೇ ಕೇಸ್ ಹಾಕೊಂಡು ಒಂದು ಡಿಗ್ರಿ ತಗೊಂಡ್ಬಿಟ್ಟು ಆಕ್ಚುಯಲ್ ಓನರ್ ನಾನು, ನನಗೆ ಅನ್ಯಾಯ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ. ಸೊ ದೀಸ್ ಆರ್ ದ ಇನ್ಸ್ಟಾನ್ಸಸ್ ವೇರ್ ವಿ ಸಿ regular complaints which we have these kind of regularly we have this kind of complaints cases, fraud or collusion in obtaining a judgment. Any party to a suit or other proceedings may show that any judgment, order or decree which is relevant under 34, 35, 36 and which has been proved by the adverse party was delivered by a court not competent to deliver it or was obtained by court. Yakidu, why this particular provision in fact refers to three different provisions, three previous provisions. See, under the previous provisions we see in respect of a probate, in respect of will, etc., what all the previous judgments of the court, previous instances before the court can be used. But what if the judgment itself was a fruit of fraud? Let us imagine if a judgment is used to authenticate a will. ನೋಡಿ ಸ್ವಾಮಿ, ಈ ಪರ್ಟಿಕ್ಯುಲರ್ ವಿಲ್ ಅಲ್ಲಿ ಕೋರ್ಟ್ ಮುಂದೆ ಆತರ ಆಲ್ರೆಡಿ ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ವಿಟ್ನೆಸ್ ಮಾಡಿದ್ದಾರೆ, ಅದನ್ನ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ. ದೇರ್ಫೋರ್ ದ ವಿಲ್ ವಿಚ್ ಹ್ಯಾಸ್ ದ ಸೇಮ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಆಫ್ ಎ ಪರ್ಟಿಕ್ಯುಲರ್ ವಿಟ್ನೆಸ್ ಈಸ್ ಬೈಂಡಿಂಗ್ ಅಂತ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬಹುದು. ಬಟ್ what if that particular judgment itself is a fruit of fraud, or a court which did not have competent jurisdiction to deliver that judgment? Then that particular judgment which is being used to prove another fact becomes irrelevant. That cannot be looked into. See how beautifully the law has been conceived and designed. 39, opinion of experts. We stop here because it is a vast area. Opinion of experts, which in fact earlier we had it under section 45 of the Indian Evidence Act. Now we have it under 35. Why number of provisions have become less means there are so many provisions which have been shrunk into a single provision. That's the reason 39 we deal with, and we have I think another 2 days 2 days, Salva, moderator, we have another 2 days. No, this is the third day.
Yes.
Yeah, in 2 days, we'll complete as much as possible. I think we'll have more of this kind of sessions in future also, where if we are unable to complete in this shorter time of 1 hour per day, the entire subject, we'll try to do it on a different. I think the Bar Council is coming out with some other program also, which I saw in some of the forwarded messages. So we'll try to push it fast through and try to do something more in coming 2 days. And for today's session, I hope you have all enjoyed and you have learned something out of me, and you will make me learn a lot out of you. Thank you so much.
Thank you, Mr. Shyamsundar sir, for discussing the nuances of the newly implemented law. Now, we just have one question due to the paucity of time. I'll read out the question, sir. What is the position in law if a statement is made in the presence of a magistrate and a police officer, but under the threat of a police officer?
Any, of course, a very, very beautiful question. I should compliment whoever has asked this question. Sometimes what we do, we see police station ಅಲ್ಲಿ ಚೆನ್ನಾಗಿ ಎದುರಿಸ್ಬಿಟ್ಟಿರ್ತಾರೆ. Under the police station, in the police station, there will be lot of threats. ಇವಾಗ ನೀನು ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಮುಂದೆ ಕರ್ಕೊಂಡು ಹೋಗ್ತೀನಿ, I am going to now take you in front of the magistrate, and there you have to tell something like this. If you don't say like this before the magistrate, then I am going to, you are going to, you will be in more cases like this. There will be some threat or inducement. Therefore, as I said, confession is open for retraction. If tomorrow the confession made is being used and the person who has made the confession is able to say, is able to prove, or even the person who is being affected by the confession of a particular person is able to show to the court that though this particular confession is made before a magistrate, should that not be accepted as a conclusive proof, because that confession in fact was a fruit of an underlying threat. That opportunity is always there. Therefore, the criminal jurisprudence which has been in practice in India for a long time and even now, it always presumes somebody as not guilty unless proved guilty. Only some laws have the presumption of guilt against the accused person. The underlying foundation, the bedrock of Indian criminal jurisprudence is, there have been a lot of, in fact, criticism also that the Indian criminal jurisprudence, Indian criminal law theories are in fact made keeping in mind the facility and the well-being and the convenience of the accused. That is the reason the Honorable Supreme Court these days has come down heavily that this direction in which we have been thinking the criminal law should have been marshaled should change. We should now start thinking from the victim center. That is the reason a lot of victim centric judgments have been coming. One such judgment is the recent judgment of the Honorable Supreme Court in Diljit Singh, where the Honorable Supreme Court said at the time of criminal cases on almost all stages, you have to hear the victim also, not just the prosecutor. So therefore, any confession, even if it is made under the mint circumstances, under the standard circumstances where the acceptability, relevancy of confession becomes usable, even those confessions can be rebutted.
Thank you, sir. That will be just one question for today. I'll conclude the session. We thank our esteemed speaker, Mr. Shyamsundar sir, for spending his precious time enlightening us about the new evidence law. We are very grateful to have you, sir, as our esteemed speaker for the lecture series. Thank you so much. This academic initiative is a week-long continuous lecture series. Beginning on Monday, it would continue until Friday, that is 12th July 2024. We request all of you to join us for the next 2 days as well to expand our knowledge about this vast topic. We certainly hope that this lecture series will help you better understand the nascent law. We hope to see you again tomorrow. Thank you for attending today's session.
Thank you all.
Thank you, sir.